All right. Good morning. Good morning, everyone. My name is Arlisha Wilson. I'm the chair of today's meeting. I'll go ahead and get us started. We'll get started by the reading of the preamble. Madam Secretary.
Good morning. My name is Liz Kukla. I'm the Secretary of the Board of Zoning Appeals, and I'm going to read the preamble for you this morning, this October 13th, 2025. In compliance with notification requirements of the city's open meeting law and section 101.021 of the codified ordinances of Cleveland, Ohio, 1976, notice of this meeting has been publicly posted. All boards and commissions under the purview of the City Planning Department conducts its meetings according to Robert's Rules of Order. Actions during the meeting will be taken by voice vote. Abstentions from any vote due to a conflict of interest should be stated for the record prior to the taking of any vote. In order to ensure that everyone participating in the meeting have the opportunity to be heard, we ask that you use the raise hand feature before asking a question or making a comment. The raise hand feature can be found in the participants panel on the desktop and mobile version and activated by clicking the hand icon. Please wait for the chair or facilitator to recognize you and be sure to select unmute and announce yourself before you speak. When finished speaking, please lower your hand by clicking on the raise hand icon again and mute your microphone. We will also be utilizing the chat feature to communicate with participants. The chat feature can be activated by clicking the chat button located on the bottom of the WebEx screen. Please note that call-in users can unmute by using *6. All meeting activity is being recorded via the WebEx platform. These proceedings are also being live streamed via YouTube for public view. We have provided a link to the meeting for those who wish to speak on a particular case via our website and email. All requests to speak on a particular matter have been considered. We have also received emails from those who provided written comment on a particular matter. Back to you, Madam Chair.
All right. Thank you. Can we call the roll, please?
Sure. Mr. Madison?
Present.
Ms. Faith?
Present.
Ms. Holzer?
Present.
Ms. Roca will be absent this morning. And Ms. Wilson.
Present.
Madam Chair, we have a quorum with 4 members. We should announce at this time for the appellants that due to us only having 4 members this morning, you run the risk of a tied vote. In the case of a tied vote, the variance is denied. So at this point, the appellants may request a postponement to a future date when we would have 5 members.
All right. Is there any appellant present who would like to request a postponement until we have 5 members present? All right. Hearing none, we're going to go right ahead into the agenda. Do we have any postponements or withdrawals?
We have 1 withdraw. Calendar number 25-167 at 548 East 102nd Street. Tamar Evans, owner, proposing to change use from single-family dwelling unit to a residential facility for 8 residents in a 2-family residential zoning district. The appellant contacted our office and does not wish to seek the variance.
All right. So we will mark that off of our agenda. Is that the final postponement or withdrawal?
Yes.
All right. Very
Excuse me,
good.
through the chair to Secretary Kukla. I think we got an email this morning from Elise Robinson. She also has her hand up. I think the email, she stated she wanted to withdraw.
Okay. Elise, is that the case that you would like to withdraw your case?
Yeah, I've been working with Shannon on something different, so that'll work.
Okay. All right. We'll go ahead and withdraw this and we will not hear this matter. This is calendar number 25-169. This is at 3848 West 130th Street. So if you are present for this matter, no testimony will be taken as the appellant has withdrawn the matter. All right. You're free to leave. Thanks, Elise.
No, thank you.
All right. So I think that concludes our withdrawals. So we'll go back to the top of the agenda and call the first case. This will be calendar number 25-147. Do we have Molly Pope with us?
Yes.
All right, go ahead and come to the table. And while you do that, we'll have Ms. Holzer read in the case.
Our first case is calendar number 25-147. This is at 1226 East 87th Street. The appellant is appealing the decision of the Commissioner of the Division of Water Pollution Control. Molly Pope, owner, appeals under the authority of Section 76-6 of the Charter of the City of Cleveland and Section 329.02D of the Cleveland Codified Ordinances from the decision of the Commissioner of the Division of Water Pollution Control regarding maintenance of a sewer connection at 1226 East 87th Street and the owner's responsibility per Section 541.30. This was filed on July 14th, 2025. And with that, I will hand it over to Mr. Madison for the oath.
Thank you. At this time, I will swear in all those who are present for this case. If you are online and would like to participate, we'll start here in the room and then we'll make our way to you. Can you please raise your hand, say your name, spell your name, as well as state your address for the record? Do you swear or affirm that the testimony you're about to give is the whole truth and nothing but the truth? We'll start here with you.
Yes, please turn your microphone on.
Thank you.
Yes,
And can you please say your name?
Molly Pope, Mollie Pope.
Thank you. And your address for the record?
1226 East 87th Street, Cleveland, Ohio, 44108.
Thank you, Molly. We'll move over to you, sir.
Gresham, Mike.
Patrick Pope. My address,
Can you spell your name for the record, please?
Patrick Pope.
Then your address?
1607 Eddie Road, East Cleveland, Ohio, 44112.
Thank you. And I do for the record? You say I do?
I do.
Thank you. Is there anyone present online that would like to participate in this case? Seeing none, Madam Chair, I'll turn it back over to you.
All right, thank you for that. Can we have legal, please?
Madam Chair, members of the board, appellant is appealing a violation notice issued by the Cleveland Commissioner of the Division of Water Pollution Control. The standard of review is whether the administrative decision was illegal, arbitrary, capricious, unreasonable, or unsupported by the preponderance of substantial, reliable, and probative evidence. If the appellant fails to meet the burden, the administrative decision must be affirmed.
All right, thank you for that. Do we have anyone from the city who is prepared to speak on behalf of this particular violation notice or from the Division of Water Pollution Control?
I see Mr. Ryan Lopez.
Yes.
Oh, perfect. Okay. So I think we'll need to go ahead and swear you in, Mr. Madison.
Thank you. Do you swear and affirm that the testimony you're about to give is the whole truth and nothing but the truth? Please say your name, spell your name, and provide an address for the record, Ryan.
Ryan Lopez, Ryan Lopez. 12302 Kirby Avenue.
And I do.
And I do.
Thank you.
You're welcome.
All right, so we will now turn it over to you, Ms. Pope. Do you want to tell us about your appeal?
When I came down to get some assistance to see how they handle the procedure of getting the sewer line fixed. But I didn't know it was gonna be an appeal, but since I'm here, will the appeal give me time for a second opinion to see whether it's really on me or the city?
No, the appeal, you're supposed to come to the table with any evidence you have that shows that the city, gave you a violation notice that was unsupported by any
Mhm.
reliable evidence.
Okay.
So do you have can you speak to that here today?
No, I just came down to get some assistance when I first came down here to see what would be the procedure to get the line fixed.
Okay.
Mm-hmm.
Mr. Pope, do you want to chime in?
Yeah, one of the questions she did have is how did they assess that it's on her, and do they have, what is the evidence that they have that it's on her property versus the city's property?
Yeah.
That's one of the
So
questions
the
she
problem
had.
is when you come in here, you hold the burden of proof.
Oh, yeah.
You're supposed to come in with that kind of evidence as opposed to just with questions.
Mhm.
But we can hear from Mr. Lopez, and he can tell us on behalf of the Division of Water Pollution Control, the basis for the violation notice, please.
Yes, Ms. Pope, we got the call from 311 on April 17th, which we then dispatched the inspector out there who requested a dye test. The dye test was performed on April 28th. The dye test did come back negative, but the hole was taking water. So that tells me it's possibly some different type of soil that will continue to take water on. So May 6th, we had our TV crew come out and televise the connection. And we found at 16 feet from the main sewer, which to the curb is 12 feet. And we're responsible for possibly a foot into the curb. At the back of the tree lawn and short of the sidewalk, there was a slight separation in the pipe. And so with that slight separation, you know, with rain, obviously we've gotten a lot of rain this year. Rain will continue to fill the hole and will slowly wash away the soil that's in there. And that's what's causing the cave-in. And so that's why the issue was referred back to the homeowner, because it's on the property. And we do have evidence to answer their question. We do have video evidence, and we have all our work orders that were put in place for the dye test as well as the TVing of her connection.
Okay, thank you for that, Mr. Lopez.
You're welcome.
Just for the board's sort of edification, can you explain a little bit about the dye test?
Yeah, so what our crew will do is they'll come on site. They will dump some dye into the hole. It's a green dye. So it's easy to be visible in the main sewer. And as they run water from the hydrant, from a hose into the hole, typically if we do it for about an hour, it usually gives time for us to see green or not see green. And so they did not see any green, again, which tells me the soil could be a sandy soil that just continues to take water, but not enough to get in through the joint of the pipe to see in the main sewer. But again, this could have been an ongoing thing for years now, and now they're just starting to see the effects of the dirt washing away through the little open joint in the pipe.
Okay, that's very helpful. Any questions from the board?
If Mr. Lopez could go through those measurements again, so we know exactly where this is occurring between the tree lawn and the house.
Yeah, so for main sewer on their street, I mean, typical main sewer from main to curb is anywhere from 12 to 13 feet. And we were able to go up 16 feet into her connection from the main and saw that there was some type of slight opening in their joint. It's hard to tell how much of an open joint it is because we can't get the camera all the way up in there to see, but just based on knowing what we do work-wise, we know that there was some slight opening there.
Okay, so we don't know how much it is.
No, we don't know how much, we don't know if the pipe's completely separated, which it didn't seem to be, because they would have put that down in their notes. But as pipe, with the ground hardening in the winter and softening in the summer, pipes do shift.
Right.
That's the nature of our industry. And so it could be a slight opening right now, but eventually will turn into something greater as time progresses.
Is there any way to do a core test to check soil samples so we know what we're dealing with there?
We typically don't. I mean, we can. That's typically not what our investigation involves.
Yeah.
But we can definitely look into the cave-in itself and see what we're dealing with.
Okay. Well, that's good to know. Ms. Kukla, could you refresh my memory what year this house was built?
Madam Chair, to Ms. Bath, we did not do research on that.
Yeah, there's
Okay.
no history given this is administrative.
Right. Exactly. No, I just thought maybe we'd have a year that it was built because clearly this is an older home looking to have been built in the 20s or, yeah, probably the 20s. So this has been a house that's been there for quite some time. Just curious. That's all I have.
Okay, Mr. Lopez, I can see that you've raised your hand. Do you have additional comment?
I do. I just, when we send these notices and we refer it back to the homeowner, I don't know if Mrs. Pope is retired or, on a fixed income. I mean, we do have resources. That's why we typically, when we send a notice, whether it's the initial notice to refer back to homeowner or a notice saying that this needs to be resolved, which is typically a 30-day notice. And it will have the information of my customer service manager to contact so we can work out a plan together. We don't just leave the resident high and dry. We will, now there's certain things we cannot do based on the codified ordinance. We cannot work on private property, but we do have organizations like Cleveland Housing Network, and we work with other people that we can help the resident get help with if there, again, is a fixed income issue. I mean, most people do not prepare for sewer issues. So again, we're sensitive to that. So we would gladly be willing to work with Ms. Pope in getting her the assistance she needs, if that is the case.
Okay, thank you for that, Mr. Lopez. Chief Leonard, I can see that your hand is raised. Do you have comment?
Yes, ma'am. Shannon Leonard, Chief Zoning Administrator. So the house was built in 1910 according to court records or the county records. But is there any way that Mr. Lopez could qualify to the Popes exactly what they need to do to remedy this situation? It seems like there seems to be a little bit of confusion over what she really needs to do.
Or Mr. Lopez, you want to chime in there?
Yes, typically when we refer back to homeowner, the resident would be responsible for hiring a licensed and bonded plumber and then, excavating and digging down to repair any necessary, whether it's broken pipe or open joint, whatever the case is. That's typically what we do when we refer back to homeowner. Again, if it's an issue where there's a fixed income and they're elderly, we would gladly give them assistance and work with those partners that we have in place to help assist them in getting the necessary repairs they need.
Okay, thank you for that. Either of you have
Mhm.
additional comment?
Yeah.
Yes, go right ahead.
Yeah, I think that sounds like something that when she came down that she was following up on, and for those reasons he stated. And like the question would be like, would it be a slight opening? Is there certain guidelines on how you could repair that versus tearing up the whole property? Or, but what he's saying is the assistance that is available. I'm sure that's what we had discussed between me and my mom, and that's the type of thing that she was trying to figure out as she came down here when they filed the hearing.
Okay, so he stated that there was a number on the original notice that you received. Do you still have that notice? Or let's do this. Mr. Lopez, can you rattle off the number that she should call to get the assistance that you were just referring to?
Yes, she would contact my customer service manager, Maurice Grayer. That's MauriceGrayer. And he can be reached at 216-664-2513. He is on vacation right now, so he will not be back for a couple weeks, but if we have our unit supervisor up front there, his name is Wallace Hollivay. That's WALLACEHOLIBAY. And if for
Perfect.
some reason they can't get in touch with anyone else, they could surely request to speak with me, and I will gladly assist them in any way I can.
Okay, so you have those phone numbers?
Yeah.
All right,
Appreciate it.
you
Thank you.
give those numbers a call.
You're welcome.
Any additional questions from the board? All right, I'll entertain a motion, please.
Madam Chair, I move to uphold the city's decision.
All right, we have a motion. Do we have a second?
Board Member Madison, second.
All right, can we call the vote?
Ms. Faith?
Yes.
Mr. Madison?
Yes.
Ms. Holzer?
Yes.
Ms. Wilson?
Yes.
Calendar number 25-147 is denied. The decision of the city of Cleveland has been upheld. We will ratify this next Monday and send you a letter.
All right, good luck to you. Very
Appreciate
welcome.
that.
No problem.
You all have a blessed quality day.
Thank you so
you
much.
too.
You do the same.
Thank you.
All right, we're calling the next calendar number, which is 25-168. Do we have a representative here from BPL Realty LLC?
Madam Chair, are we skipping 25-162?
-1, no, we are not. That was my error.
All good.
So I did skip one. I'm going to go back. So 25-162. This one is Eric M. Assad. Do we have anyone? Okay, come forward. And while you do that, we'll have Ms. Holzer read in the case.
Our next case is calendar number 25-162. This is at 3591 West Park Road. It is a violation notice. Erica Masad, owner, appeals under the authority of Section 76-6 of the Charter of the City of Cleveland and Section 329.02D of the Cleveland Codified Ordinances from the notice of violation number V25025-167 issued on July 30th, 2025 by the Cleveland Department of Building and Housing for failure to comply with sections 325.03 and 327.02, which state that the installation or modification of an accessory off-street parking spot, I imagine, requires a permit issued by the Department of Building and Housing. And this was filed on August 19th, 2025. With that, I will hand it over to Mr. Madison for the oath.
Thank you. At this time, if you are interested in participating in this case, please come forward. If you're online, we'll come to you following this as well. But please, you can have a seat at the table and or bring your chair up. Please raise your hand, reply if I do, and your name, and then provide your address for the record. Do you swear or affirm that the testimony you're about to give is the whole truth and nothing but the truth? We'll start here with you.
I do. Excuse me, sir. Sorry. Can you click that red button? Oh, you can get. Thank you.
I do. Eric Assad, ERICASSAD, 3591 West Park Road.
Thank you. Same with the green button.
I do. Mary Brightwig, MARYBREITWEG, 601 Lakeside Road, Cleveland, Ohio.
Thank
And
you.
which department are you with, Mary?
Councilman Charles Slife's office.
Okay, thank you for that.
Is there anyone else present for this case? Seeing none, Madam Chair, I'll turn it back over to you.
All right, thank you for that. Can we have legal, please?
Madam Chair, members of the board, appellant is appealing a violation notice issued by the Cleveland Department of Building and Housing. The standard of review is whether the administrative decision was illegal, arbitrary, capricious, unreasonable, or unsupported by the preponderance of substantial, reliable, and probative evidence. If the appellant fails to meet this burden, the administrative decision must be affirmed.
All right, thank you for that. And I will now go to you, Mr. Assad. Do you want to tell us about your appeal?
Yeah, absolutely. And I want to apologize for the paper packet here. I received the violation or received the notice for submission a little bit late. So we're going to go back to the late 80s for stapled packet here. So first off, good morning and thank you for being here on a Monday morning after another embarrassing Browns loss. I know we're all busy, so I'll try to keep it as brief as possible. In 2008, I purchased a home at 3591 West Park Road, fully knowing the property did not have a driveway or a garage. I was so excited to be a homeowner. I viewed it as a minor inconvenience. And for 16 years, my wife and I parked on the street and dealt with everything that comes along with that. This includes my wife's car being sideswiped, waking up at 5 a.m. to shovel the street after snow plows buried in our cars, parking a block away when they do street cleanings, and having my truck broken into 2 times. In 2022, we decided we needed a little bit more space and a driveway. It was important for us to stay in the city, so adding on to our current home was our first option. Over the next 3 years, we saved our money and conceptualized our plans. Knowing fully the unique lot shape posed some difficulties, we wanted to get the driveway approval before we finalized our addition plans. After doing some research and consulting with a contractor, it was apparent that the variance would be needed regardless of where the driveway was poured. In November of 2024, we submitted plans for a new driveway, apron, curb cut, and sidewalk realignment. 5 months went by without an official ruling while we prepared for an appeal, but much to our surprise, on March 3rd, the driveway plans had been approved. In the packet that I provided, there's printouts of the months of interactions that we had throughout the entire process. So on page 1, going back to January the 17th, we have interactions with the city and my contractor discussing the zoning review. And I've highlighted just kind of getting through the process, acknowledging that there was probably going to be a need variance. On page 2, we have an email from the contractor acknowledging the lack of a ruling and how to move forward with the appeal process if that were necessary. On page 3 is another email from early February to the city discussing planning options. And in this email, it's kind of requesting or kind of acknowledging what, the ideal spot for the driveway would be. Page 4 is an email from the city discussing zoning and setback issues. At this time, we had multiple Zoom meetings and team meetings with the city, looking at aerials of the property, trying to figure out the best driveway design given the oddly shaped lot. Unfortunately, I was unable to find the history of these meetings. However, this is where the city laid out where they wanted the driveway to be poured for approval. I contacted Zoom to get confirmation, but they were unable to provide me with any evidence due to privacy issues. On page 5 is an email from mid-February from the contractor trying to move forward with the project. On page 6 is the day we had been waiting for. On March the 3rd, much to our surprise, the driveway, sidewalk, and apron had been approved. It's hard to explain the excitement we experienced after parking in the street for 16 years and 5 months of back and forth interactions with the city. I even think that night we had opened a bottle of wine to celebrate, knowing that our parking nightmares would soon be over. On page 17 is an email from March the 19th, giving the go-ahead to move forward with the plans for the addition. With the driveway approval, we now knew where we'd be parking, so we designed the addition around having the driveway in the front yard. On page 8 is an email from May the 22nd from the contractor submitting the addition plans. And page 9 is the site plans with the driveway and the addition. And I apologize for the copy here. I was having some printer problems. So
And just a quick question.
Sure.
Are these the plans that you submitted that had been approved in one of your recent emails that you mentioned?
yeah, so there were 2 different approval processes. One was for the driveway, the sidewalk realignment, and the apron.
Okay.
Once those were submitted, or once those were approved, then we went forward with the addition. The city had requested that we submit the site plans that had the approval of the driveway and the addition together now. We did it separately, like I said, because we didn't know exactly what we wanted the design to be, given that, maybe it was going to be in the backyard, maybe it was going to be in the front yard. And so obviously the design of the actual building was going to be different depending on where the city said we can put the driveway.
Okay.
Okay.
Understood.
And if you guys needed to see a more detailed plan of what we submitted, I would be able to provide that for you. I just couldn't get anything to print out, clearly. On page 10 is an email from June the 3rd from the city approving said plans from page 9. On pages 11, 12, and 13 are copies and emails of the permit. And I have highlighted some sections that explain exactly what the intended scope of work was going to be. Page 14 is a copy of the work order site plan detailing the work to be completed. And again, I've highlighted some of the detail work that was going to be performed. Page 15 is an email from the contractor to the city discussing the driveway inspection. At this point, we had permit in hand. Everything had been scraped and we were ready for inspection from the city. On page 16 and 17 are text conversations between the contractor and the inspector, clarifying the inspection and the approval. And that brings us to today, Monday, October 13th. If I'm being honest, I still don't quite understand what happened and what went wrong. I was able to demonstrate the lengths that we went to get through the approval from the city and do things the right way. Throughout this 11th month process, at no point were we denied a single approval or failed inspection. The last couple of months of having a driveway to park in and some extra space in our beloved West Park home have been truly life altering. I'd be happy to answer any questions from the board to clarify anything I discussed today. And I ask you to please rule in my favor so we can move forward and continue to enjoy our new life. And if I can just I wrote all this down because I didn't want to forget anything. But just to speak sincerely, I don't know what happened here. Seemingly we did everything right. I've called the city multiple times to try and see exactly what went wrong. For all practical purposes, I'm a good neighbor. I mow my lawn, I recycle, right? I'm just confused of exactly what happened here. In this process, I've done a lot of the work on the exterior of the house myself, and the support that I've gotten from the community has just been overwhelming. I have people who walk to the coffee shop across the street. They stop and talk and say how excited they are for me because, they've noticed that our cars are out of the street. And I'd imagine the city of Cleveland too would love to have some cars off of the street as well. So, when I called the city after the violation was issued, I got kicked around to a bunch of different desks, a lot of no callbacks that still failed to tell me exactly what I did wrong. Hopefully I've demonstrated that I really did try. If there's some technicality, I feel like that was something that should have been issued before the inspection, before permits were issued. We just went forward with exactly what everything the city had approved for us. And so that just is kind of where we're at here today.
Okay, so one quick question. You
Sure.
stated that the inspector came out to inspect the finished work and that inspection was approved. Can you point us to where in this packet of information you received an approval?
You know what? I don't have an official approval letter. Obviously the city would have that. I don't actually, my contractor is here.
Thought that
Go
was
ahead.
you. We got to swear you in. If you want
Oh.
to speak, come forward. You can pull a chair up. And I'll just quickly ask, do you swear or affirm that the testimony you are about to give is the whole truth and nothing but the truth?
I do.
All right, can you state your name and spell your name?
Matt Assad, Mattassad,
Okay, and give us your address.
6185 Bellarmine Drive, North Royalton, Ohio.
Okay, go right ahead with your comment.
So Antelise Hankins was our inspector and just on site verbal approval, but she said she was also going to file something with the city. I never got an email from her with the actual approval, but typically the verbal approval is enough. Say it's good to pour. So.
Okay, understood. Thank you for that. Any questions from the board? All right, I will turn to you next. Go right ahead and give your comment for us, please.
I have a letter from Councilman Slife. Unfortunately, due to family commitments, he was unable to attend today, so I was just going to read that.
Okay.
Dear Chair and board members, due to the family commitments, I am unable to attend today's board meeting concerning calendar number 25-162 at 3591 West Park Road. Please accept this letter transmitted by Mary Brightwig from my office in my absence. Mr. Eric Assad is before you today to appeal the violation he received related to the installation of a driveway within the setback of his property, off-street parking that requires various approvals from the city of Cleveland to be legal. In writing today, I ask that the board grant this approval and that the city staff work with him to make this current condition legal. Mr. Assad's property is located at the corner of West Park Road and Tuttle Avenue on a large intersection commonly known as 5 Points. Previously, 3591 West Park had no off-street parking despite having 2 frontages. In July, I noticed the framing of an apparent new curb cut onto West Park Road and a corresponding driveway. I immediately contacted city departments with concerns only to find that the Division of Engineering had issued a permit to install a new curb cut across the tree lawn as it is the legal right-of-way. However, the Department of Building and Housing had not issued a permit for off-street parking, nor had the Board of Zoning Appeals issued a variance for parking within the setback. In speaking with Mr. Assad, he states that he spoke with city staff, directly with city staff. I'm unclear of who or where, who advised that the driveway at this location would be preferable, given the constraints along Tuttle Avenue frontage related to the shape of the parcel. Concurrently, he was not advised of the full series of approvals that would be necessary. It seems a drop in communication between permitting departments led to a scenario where a curb cut was approved for an otherwise illegal driveway, and that city processes did not catch the conflict, since the curb cuts typically access legal driveways and driveways within setbacks are rare citywide. With this background information, I have become convinced that Mr. Assad acted in good faith and was unaware that the additional approvals were required. At this juncture, upholding the violation and causing the property owner to fully remove the driveway would affect him financially. I believe it is prudent to review interdepartmental permitting rather than punish the property owner for the flaws in city processes. Again, I support Mr. Assad in his appeal of the violation. Thank you, Charles Slife, Councilman, Ward 17.
Okay, thank you. Those comments
Do
are
you guys
noted.
need copies of the letter?
I would say yes, give a copy so that it's in the record. And then Chief Leonard, I can see that your hand is raised. Do you want to chime in?
Yes, good morning, Madam Chair, Chief Zoning Administrator Shannon Leonard. So this was a situation, as the councilman's assistant stated, where you had various approvals going on from various departments. So I believe Mr. Assad or his contractor, on one hand, went through our traffic and engineering department, but also building and housing. The plans that we received in building and housing that the plans examiner reviewed initially, the plans were very small, and there was an error in terms of the zoning approval. At the same time, they were also given approval and request from the traffic and engineering department regarding the placement, as this being the ideal placement for whatever reason. And so they were given the permit to go ahead and pour, is my understanding. The issue here, and the reason why I think the violation notice went out, was halfway through the summer, there was a realization that this violates the zoning code. And so a letter of nonconformance was to go out by the plans examiner, and it did not. So we still need to issue that letter of nonconformance so that the applicant can go through the proper process. But essentially that's the case here.
And for the record.
Hold
I'm
on
sorry.
one
I'm
second.
sorry.
I'm going to ask if any other board members have questions. Okay, I'll give you the floor, Mr. Assad.
And for the record, we would have been happy to put it wherever the city approved. We just wanted to get our cars off the street. So, because there was a technicality or some kind of mix up, there was no, we weren't trying to like strong hand or try to sneak anything in this situation. We really tried to do everything right here. So, yeah, I mean, as far as being in violation of something that was illegal, I feel like there was a time to discuss that. And after the driveway was poured is definitely not that time.
So Chief Leonard, we have been given a packet of information from the appellant. And on page 6 of this packet of information, there is an email from Marcos Torres, and it's dated March 3rd, 2025. And this email states that the zoning review for this project has been approved. So my question is, if it was represented to the appellant that the zoning review was approved, how then do we go back and violate him for the same thing that had already been approved?
Yeah, so I think there was a difference in plans that was received from building and housing versus what was received by traffic and engineering in terms of the driveway pour. And so generally speaking, Chief Vanover, in terms of the zoning approval, from an enforcement standpoint, the idea is that, obviously the project is already completed, as you can see here, but they still need the variance for parking in the front yard setback. So there was a confusion between the plans that were submitted to Building and Housing in terms of the addition versus where the driveway was going and where the curb cut was going to be.
So then now my question is to you, Mr. Assad. In terms of the plans that you submitted, and perhaps this may be a question for you as well, was there a difference in the placement of the driveway, meaning in the plans that you submitted specifically for the driveway and the plans that you submitted for the addition?
I can speak to that. There was a change because once, in one of our Zoom meetings with Mr. Torres and Mr. Lull, they informed me we needed a 10-foot setback from the house where the initial plans didn't. The initial plans had it almost like an actual driveway going directly into the house. That's the only change that was made. The driveway in that spot with the same curb cut in that location never changed.
So the
The
driveway
shape
was
of the
always,
driveway changed.
okay,
That-
okay. So what was the shape of the driveway in the first plan compared to the
It,
next
so it
plan?
went directly, if you can see here, it went directly into the house and then there to the left, there was a part of the parking pad almost.
Okay,
A turnaround.
so you removed the turnaround in the second plan?
Correct, yeah. So they told me that would be basically going too far, too close to the house, that would never get approved, and then the turnaround as well. So a straight shot in was what we decided on that call.
Okay, and then that plan was approved?
Correct.
Okay. Okay, Chief, I can see that your hand is raised. Do you have additional comment?
I do not.
Okay, very good. Any questions from the board? All right, I'll entertain a motion, please.
Madam Chair, I move to vote in favor of the appellant, given today's testimony before the board.
Okay, thank you for that, Mr. Madison. Is there a second?
Board Member Holzer, I second.
All right, thank you, Ms. Holzer. Can we call the vote?
Ms. Faith?
Yes.
Ms. Holzer?
Yes.
Mr. Madison?
Yes.
Ms. Wilson?
Yes.
Calendar number 25-162 is granted. It'll be ratified next Monday. We'll send you a letter, but you can contact us next Wednesday for further instruction.
Thank you so
All
much.
right,
I
you're
really
welcome.
appreciate it.
Good luck with your project.
Thank you.
Should we give you this for the file? We'll pass that
Mine
down.
too. Do you want these?
All right, I'm not gonna skip a case this time. Stop me if I do, though. Calendar number 25-168. Do we have anyone here from BPL Realty? Okay, come forward, and while you do that, we'll go ahead and read in the case.
Our next case is calendar number 25-168. This is at 12204 Lorraine Avenue. BPL Realty LLC proposes to establish use as a smoke shop in an existing retail storefront in a C2 local retail business district. The owner appeals for relief from the strict application of the Cleveland Codified Ordinances as stated in the agenda and the public record, of which there are 3. And with that, I will hand it over to Mr. Madison for the oath.
Thank you. At this time, we'll swear all those who are interested in participating in this case. You'll please raise your hand, reply if I do, state your name, spell your name, and provide an address for the record. Do you swear and affirm that the testimony you're about to give is the whole truth and nothing but the truth? We'll start here with you, sir.
I do. Breon Martin, DJ Sims Consulting. Address is 46 Shopping Plaza Drive, Chagrin Falls, Ohio, 44022.
Can you please spell your name for the record?
BRIONEMARTIN.
Thank you. We'll move to you, madam.
My name's Tina Gassner. My address is 12204 Lorraine Avenue, Cleveland, 44111. Spelling of my name is TINAGASNER.
Thank you.
Do you swear?
Yes, ma'am.
Okay, thank you.
Good morning, Nate Lowell, Cleveland City Planning, 61 Lakeside Avenue. I do.
Thank you. Is there anyone else present? Please come forward to participate in this case.
Thank you. Dennis Butler, I'm an attorney for the city of Cleveland.
Okay, you want to come forward? Just pull up a chair.
Is there anyone else present for this case? I see there's someone online. Austin, we'll move to you. Please,
Austin Raymond. Austin
Thank you.
Raymond, AUSTINRAYMOND. Jefferson Puritas West Park Community Development Corporation, 14703 Puritas AF, Cleveland, Ohio, 44135. And I do.
Thank you. Is there anyone else present? Seeing none, Madam Chair, I'll turn it back over to you.
All right, thank you for that. Mr. Madison, can we have history of the property, please?
Madam Chair, we actually have a legal question maybe for the law department with the governor's statement on these items and the moratorium. I think it was a 90-day moratorium. Should we be really considering this case at all right now?
Okay, Mary, that would be a question for you. Can you chime in, please? Or is that something you would want to speak to Mr. Butler?
It's not something I can.
Okay, Mary, please help us out here.
I don't know anything about the moratorium. I'm sorry.
Ms. Leonard, please help us.
Okay, Chief, I can see that your hand is raised.
I think that this can go forward. I mean, smoke shop is defined as all encompassing of THC products, tobacco products, things of that nature. However, all of the products that have THC and hemp, the governor did issue a moratorium that those items must be removed from all smoke shops or all shelves across the state until further notice. It is initial 90 days. The health department is waiting to see if there is any decision by our legislators. But I do believe that this can go forward because they're trying to establish the use as a smoke shop, but a smoke shop is more than just the THC products.
Okay, thanks for clarifying that for us. Madam Secretary, that answer your question?
Yes, absolutely.
Okay, perfect. All right, well, we'll go to history of the property.
Okay, this property was originally zoned general retail in 1929. In 2007, it was changed to local retail business and placed in a pedestrian retail overlay district. Our records administration office show that this project is in a range of addresses, starting in 12204 through 12208. For 12204, we found, I'm sorry, for 06, we found that in 1928, a permit was issued for alterations to a dry cleaning shop. And then in 1967, a permit was issued to demolish a one-story dry cleaning plant on the property. After that, the records are kind of shoddy. I didn't really find much. We didn't really find much else until the more recent history. In 2000, we found a permit was issued to construct a 12-yard car parking lot with fence and landscaping. We found that there was a violation notice issued in 2014 for exterior maintenance to a structure on the site. Later in 2014 and May of 2014, the first one was in April. Second one was in May of 2014. It was interior maintenance violation notice issued regarding residential units on the property. And then, Madam Chair, we see that then in June of this year, there was a civil ticket regarding the windows being covered more than 25%. There are no variances on file for this address. Thank you.
Madam Chair, should I go? Madam Chair, members of the board, appellant is requesting area variances from the minimum distance and permit application requirements of the zoning code. To obtain the area variances, appellant must prove that denying the request will create practical difficulty not generally shared by other land or buildings in the same district, will deprive the appellant of substantial property rights, and that granting the variances will not be contrary to the purpose and intent of the zoning code.
State your name.
Breon Martin, DJ Sims Consulting. And I just want to make clear, I'm not acting in a legal capacity. I'm acting as a consultant who helped Ms. Gassner prepare for today. No.
Not. I am Get Lit Tobacco and Vape Store. I'm the store inside that building.
Yes.
Okay, so as BPO.
Trying to get the occupancy license. The building, I don't know.
We were expecting them. Yes.
Yeah, I do not see anything in the file. Any authorization forms?
Okay, so usually. We do.
Sorry, I just noticed your mic is off. That's sorry.
I don't know why the mic is off. Okay, but hopefully you kind of picked up what I was saying. Could maybe one of you give a call to BPL and see where they are? Um,
Well, your landlord, yeah.
Yeah.
okay, so we'll hear from Mr. Martin and then you can step out and place a call. Yep, and just come right back when you're done. All right, Mr. Martin, go right ahead.
Pardon me, Dennis Butler for the city of Cleveland. If we're waiting for BPL to be present in the meeting, does it make sense for us to go forward without them?
Well, we
partially?
don't necessarily have to have them to be present. We just have to have authorization. So what we could do is just take the testimony and then they could send the authorization, you know, after the meeting. We just want to make sure that they are on board here.
Madam
So,
Chair,
yeah,
could I recommend that, that we hear another case while we wait to get the information regarding the authorization?
sure.
I think that'd probably be best. Maybe just table it until they get their authorization forms to ensure that they get them prior to the hearing.
Would we need to reschedule?
Do we have anything? Okay. Does he have the information
Do you have the
to?
information, Chuck? Do you have the information to Zoom in?
In my email?
In his email? Yeah.
How would he have received the link?
So, I don't know, if you want to do the email or my cell phone, what ask what's easier for them?
Email.
Chuck. Make sure it's put in this computer. Okay, let's just do GETCAR LTD. So it's getcarltd@gmail.com. I'm watching it right now. Zoom in right now.
Okay, they're gonna send you an email with the link to join the meeting.
We're sending you it right now to join the meeting.
Okay.
And just to be clear, you authorize Breon Martin and Tina Gassner to speak on your behalf?
They're talking to you, Chuck.
I couldn't hear what they're saying.
Do you authorize Breon Martin and Tina Gassner to speak on behalf of your company BPL Realty?
Is that what you said?
Yes.
Yes.
And do you authorize Breon Martin and Tina Gassner to speak on behalf of the company?
Their company, yes. Not BPL Realty.
Okay.
For myself, I got here soon.
Okay.
It's a storefront and she runs legitimate business. And then all of a sudden, all these other places are popping up. So they started giving her a hard time. No?
Okay.
That's our goal is to get a use permit.
Well, he's not
for
sworn
her
in,
to
so
I would
maybe
object
he
to
should
this
not,
going
he should
forward.
stop.
Does he have the email link? Okay.
The link. Yeah, I think
Or
we
join
have.
meeting, I see it. Okay. Gotcha.
All right, I'm gonna hang up.
Okay, wait. So download the WebEx. I don't know if I have that. I'm trying to do it from my phone, Tina.
All right.
Send it to another email that's on my phone where I have the Zoom app.
Well, it's not Zoom, it's WebEx.
It's WebEx, she said, not Zoom.
And instead of downloading, you can just say click and join meeting.
Okay, enter name, Chuck Sullivan.
Mm-hmm.
No microphone found. Join meeting, okay. Alright, I just come in. You guys hear me?
Yeah, you're up there. I'm gonna hang up.
Okay.
Okay, thank you. Bye.
All right, hopefully we can get him to unmute the mic so that we can actually hear him. Chuck Sullivan, can you hear us? You are on mute, so we cannot hear you. You have to unmute your microphone. We still cannot hear you. Your microphone remains muted.
There he is. Hello?
Almost like you didn't give it
It
permission.
says no microphone
If we
found.
could do
he
it through
said.
the phone, that would be cool. I mean,
Is there a call-in number for WebEx?
probably not.
They're checking to see if there's a calling number. No, for here. I don't think you can be on my, the record, you gotta be on there.
Same email. The call-in number is in the same email.
Yep.
Yes, please call that number, yes. Yes, please. Okay, thank you. I'm sorry.
Okay.
So, Madam Chair, there still will be a question. We don't seem to have any LLC paperwork, to show that this Mr. Sullivan is actually in the, is in the incorporation. So we always ask for articles of incorporation when a person applies with an LLC. And I do not see any of that in the file as, right now. So it's still, it will be some question as to whether or not he is authorized to speak, if he's actually a principal in the LLC or the LTD.
So we'll just have to make it a condition of the motion.
And we have done that, yes. We take testimony and then ask for the paperwork afterwards. We have done that.
Which is what I was just getting ready to do, just for the sake of us not wasting time here. I think we can proceed and take testimony, and then we'll hear from Mr. Sullivan once he gets all of the technical ducks in a row. So with that, Mr. Martin, please proceed with your comment.
When Cleveland, Ohio passed the new ordinance specifying that smoke shops needed to be within a certain distance of schools and churches and each other. It happened, the law took effect in April of 2025. As a result of, I believe, a citation by Building and Housing, Ms. Gassner needed to apply for an occupancy permit, and there was a fine written to BPO Realty, or a fine that BPO was responsible for because of the window signage. So I was informed that the occupancy permit was going to automatically be denied unilaterally because that there was a new law that went into effect, and smoke shops are not having support from the council people who had recently passed the law. Ms. Gassner definitely needed a occupancy permit before then. However, due to some life circumstances which were rather extenuating, and Ms. Gassner believed that she was operating within the law, she was unable to obtain it. And so we sit before you today to seek some more of a compassionate appeal process and hopefully an approval, considering her extenuating personal circumstances that allowed the need for an occupancy permit to slip her mind.
How long has the business been open?
She's been there for about 5 or 6 years. 4, I believe, of those 5 years, she has a tobacco license from the state of Ohio, Department of Taxation.
Okay, and so why wasn't the occupancy permit obtained 5 years ago or 6 years ago?
To my understanding.
You know,
State your name and then give your
Gassner.
Mhm.
Originally, I didn't realize that I needed it, which is my fault. The city had come in, the firemen, all that would come in and do inspections, check my license, all that. I thought it was good. Then I had 3 strokes in 3 years, and it just trying to get back from that. I just haven't had the time to go get it. I should have. I didn't. So this is where I'm at now. I did apply for it. I got denied right away. I've been there a while. I should have done that. I mean, I can't.
Okay, do you have any other additional comment? Okay, Mr. Law.
Yes, Nate Law, Cleveland City Planning Department. I'll keep it brief. Since the new law has gone into effect, we have not supported smoke shops in the city. Any smoke shop that had a occupancy license before or had a permit in before the new law took effect would have been grandfathered in under the old zoning code. But once the new rules were passed and any occupancy permit was applied for, we have to apply the new zoning code regulations to that. So we would not be in support of the variance simply because it does, granting the variance would be essentially the opposite of what the zoning code provisions state.
Okay, and can you speak to the saturation in this area?
Yes, so we have a map here that demonstrates the number of smoke shops. In the green dots, there are occupancy permits that have smoke shops that have occupancy permits existing. And then there is a 500-foot buffer, which is the pink circled area. And I think there's some other items on the legend that show where these buffers are taking effect. So essentially where the star is where the business is. So it is within 2 miles of 3 existing smoke shops that are legally licensed smoke shops.
Okay, understood, thank you. All right, Mr. Raymond, do you want to give your comment?
Yes, just to let you know, we're not in support of it. I've talked to Councilman Casey about it. Just to let you know, there's an unlicensed one across the street. Even though that's on our ward, it's in the general vicinity of this location. We take a strong stance against smoke shops and variances for smoke shops. Also, they've never had a certificate of occupancy to begin with. So we're against it.
Okay, thank you so much. Mr. Butler.
Yes, the city is against the granting of this variance. In this hearing, I don't believe that the applicant has demonstrated that the practical difficulty or unnecessary hardship adheres in and is particular to the premises sought to be built upon or used because of physical size, shape, or other characteristics of the premises or adjoining premises which differentiate it from other premises in the same district or create a difficulty or hardship caused by a strict application of the provisions of this zoning code not generally shared by other land or buildings in the same district. We saw a photo of the smoke shop. It looks like any other, not only just smoke shop, but any other shop. It doesn't have permanent signage. There's nothing about it that kind of differentiates it from any other shop out there. We also don't believe that they've demonstrated that the refusal of the variance appealed for will deprive the owner of substantial property rights. This store can still be used. This does not mean that they're out of business. They just have to work within the zoning codes. My understanding is they have to limit their shelf space of smoking items to less than 20% of the store, which they can do. They also haven't demonstrated that the granting of the variance appealed will not be contrary to the purpose and intent of the provisions of this zoning code. The zoning code was intended to limit smoke shops in the city of Cleveland. It was intended by the lawmakers that some smoke shops would be shut down during this, as a result of the zoning code. The only other two reasons here, there's two violations here. The proposed smoke shop is within 2 miles of another existing smoke shop, which I believe it's within 2 miles of more than one existing smoke shop. Also, it's within 500 feet of several either church, public library, public playground, public park, or schools. Not just one, several. And so for those reasons, we ask that this variance not be granted.
Okay. Ms. Gassner, go right ahead.
Within 500 feet, I've been around there, that the school that's there is closed down, has been closed down for years. The smoke shop across the street is not a smoke shop. They're gonna, with this THCA law, that store is gonna be gone. The smoke shop down the street from me, closed up because of the occupancy thing, so they're gone.
Record Smoke City.
Yeah, Smoke City, so I don't know where the daycare is. I don't know where the church is. I know the school is shut down. There's no park associated with that school building anymore. So
if you look on the map, it gives you an indication of where the smoke shops are, the daycares, as well as the church.
I mean, I'm in that area. Are these open churches or just buildings? Because
And I've canvassed the area too,
I mean,
completely.
So as the appellant, you have the burden of proof here. Can we put the legal standard back on the screen, please? And it's your burden to come in with information, with evidence to show, contrary, what the allegations are stated. And as you can see, the legal standard is spelled out there. So you do have to speak to there being a practical difficulty, not generally shared by other buildings in the same area. So is there something that you can say in terms of practical difficulty?
Would you explain practical difficulty?
Sure, like a challenge or something that would make it a difficult process for you to follow the actual zoning code that would warrant this board granting a variance.
Well, to my understanding, Ms. Gassner has depleted her life savings, building and establishing this business. And to the point where the idea that she applied for a general retail occupancy permit, it would create a huge economic burden on her because she was operating with, under the understanding that she was okay after having visitation from the city. That I think that allowing her to be grandfathered in would keep an existing business that has so much of one person's who's up in age in terms of lifespan, the opportunity to not have to start completely over. Acquiring other stuff to sell in a store creates an even bigger burden because of the learning curve of learning another industry. So I think that it would be fair and equitable. And there are examples of this very concept, which has happened in some in Cleveland, but across Ohio law. Not that I'm an attorney.
Okay. Did you?
I mean, yes. This is not just it's not just that a practical difficulty must be shown. It's a practical difficulty that's not generally shared by other land or buildings in the same district. And so while we do recognize that is a practical difficulty, it's not generally, it's not different than any other land or buildings in the same district. And as far as health challenges and things like that, even if there weren't these challenges in the past, it is the city's position that this likely would not have been granted anyway. So that's all I have.
Okay, any questions from the board? All right, Chief Leonard, I can see that your hand is raised. Do you want to chime in?
Yeah, just a couple things. They had stated they've been in business for 5 years. The issue here is that they've never even sought out a occupancy permit at all in those 5 years. And so anytime you operate a business in the city of Cleveland, you need either what was previously called a certificate of compliance or a use permit, and in the last 30 or so years has been called an occupancy permit. Additionally, as it relates to the governor's moratorium or executive order that was signed last week, that's only temporary. That's only if the legislators come up with something. The smoke shop legislation was put in place for the variety of reasons in terms of really protecting the public health and safety of our residents and our other businesses. And then additionally, those daycares and other items that you see on the list are actual occupancy permits that are within the system, or they're registered, they have state licenses from the state. So those are all, whether, they operate in the evening or during the day, those are actual permits that we have that we mapped off of. But those are items just to keep in mind that, like, even though the moratorium takes THC products off just for the next 90 days, that doesn't mean that those won't go back on the shelves, and the state still hasn't completely regulated them in any kind of way, or in terms of putting an actual age limit on them either. So just so you all are aware that is just a temporary ban, but it's not permanent.
Ms. Gassner,
Okay, hold on 1 second. Thank you for that, Chief Leonard. Chuck, are you able to chime in here? See if we can hear you. Chuck, are you there? We're not hearing you. I don't know if he was able to call in. I'm not seeing a call-in user at this time. Did you have additional comment?
yes, Ms. Gassner doesn't sell marijuana-related products. Ms. Gassner sells strictly tobacco and cigarettes and things of that nature, cigarettes, smoking accessories.
Okay, and is her shop selling 100% of those items, or is it less than that?
It's about 100%.
All right, any questions from the board?
Madam Chair, I'm just looking at some historical photos, and it looks like as of June 2019 is when the temporary sign went up on the facade of the building, which is what is displayed in the current photographs. And also in the historical pictures, there is a banner sign out in the tree lawn advertising the shop. The child care center is across the street and probably about mid-block, so almost kitty corner from the business. And the church is north of the business. Small church, but it is a church nonetheless.
Madam
Okay.
Chair.
Thank you for that, Ms. Faith. Yes, Chief Leonard, go right ahead.
So I'm going to read to you what the application was for. Sales of tobacco, CBD, kratom, nicotine products, electronic cigarettes, vaping devices, and tobacco accessories. So those are all items that are considered smoke shop products. which defined this as a smoke shop when we did the zoning review.
Okay, thank you for clarifying that. All right, if there are no questions from the board, I'll entertain a motion.
Yeah, Madam Chair, given the testimony today, I will move in favor of the city's recommendation and deny calendar number 25-168 and encourage the applicant to work with the city as they move forward within their own business plan.
Okay, thank you for that, Mr. Madison. Is there a second?
I second.
Thank you, Ms. Faith. Can we call the vote?
Ms. Holzer?
Yes.
Ms. Faith?
Yes.
Mr. Madison?
Yes.
Ms. Wilson?
Yes.
Calendar number 25-168 is denied. This decision will be ratified next Monday, and we will send the appellant a letter.
All right, thank you everyone for being
for
here
your time.
today. We're going to move now to calendar number 25-148. I do think I see Mr. Garcia online, so we'll go ahead and read the case in. Ms. Holzer?
Our next case, and I believe our final case, is calendar number 25-148. This is at 9917 Hamden Avenue. Enrique Garcia, owner, proposes to erect a front porch attached to a single-family residence in a B12 family residential district. The owner appeals for relief from the strict application of the Cleveland Codified Ordinances as stated in the agenda and the public record, of which there is one. This case was postponed from September 15th to allow time for the appellant to revise plans to show an open front porch. And with that, I will hand it over to Mr. Madison for the oath.
Thank you. At this time, I will swear those present for this case. Do you swear and affirm that the testimony you're about to give is the whole truth and nothing but the truth? At this time, please raise your hand, reply if I do, say your name, and spell your name for the record and provide an address. We'll start with you, Enrique.
You're on mute. You have to press the unmute button so that we can hear you. Nope,
We still can't hear you.
Still can't hear you. You've got to press the unmute button on your computer. There should be a microphone with a red slash through it. Not sure if it comes through that way on your end. Can we send him a prompt to unmute?
And Madam Chair, just to give you if you remember this case, it's a minor variance. The appellant was asking for an enclosed front porch, and we found that the board did not have the authority to grant the enclosed front porch. So we asked the appellant to revise the drawings and give us an fully open front porch, and that's what we have now. However, he still needs a variance for 4 inches.
Understood.
So I don't know how much testimony you're going to need. You may want to hear from the city, but it seems like it should be a pretty easy case. Thank you.
Okay. All right, you're still on mute, Mr. Garcia. We got to figure out how we get you off of mute. I don't know how to work WebEx. How do you unmute on WebEx? If you look at the bottom of your screen in WebEx, you should see a list of options at the bottom, and one of those options should be a microphone. If you could click that microphone. Join WebEx so I could see.
Look for the word unmute, UNMUTE. Click that button, please.
We can see that your lips are moving, but we still can't hear you.
Anyone that speaks Spanish?
Madam Chair,
Yes, Chief Leonard.
can I go ahead and just kind of talk about what the variance need is here while he's trying to figure out how to get unmute?
Sure.
So as Secretary Kukla stated, they had come for the enclosed porch. Obviously, that was not a permitted encroachment. So they're asking to do just a regular porch. The difference here is just 4 inches. So you can encroach with a porch up to 8 feet, and they're proposing 8 feet 4 inches. And the purpose of that is because they're using the existing fence porch foundation that came down. That porch came down at some point previously. So it's really just a 4-inch variance that they're requesting here.
Okay, thank you for that. I mean, I do want to give you the opportunity to speak, Mr. Garcia. Do you see in WebEx where there is a red X at the very bottom of the screen? Can you see the red X? Because near the red X is how you unmute yourself. There's a few buttons to the left of the red X. Alternatively, we can have you call in. We can't hear you.
Can we tell if he's on his phone or on a computer?
Looks to me he's on the computer.
All right, it differs a little slightly if he's on his phone. Maybe we can just have him call in, Madam Chair, since this is a 4-inch variance.
Mr. Garcia, can you hear us? Give us a thumbs up if you can hear us. If you can hear us, put your thumb up in the screen. I don't even know that he can hear us. All right. Do we want to vote on the variance without hearing from the appellant? I mean, I don't know if that's proper procedure.
Do you think we should try and call him? Can we reach out to him by phone?
Is it? Oh, there's one in the
We could also do history and legal because I don't think we've done that. We did do that? We did? Okay.
Could we have Mr. Bay put up the image of the,
yeah.
Yeah, I don't think we did history of the property.
okay.
I did not do legal yet.
Yeah, I didn't think so. Okay, give me 1 second.
504 2 508.
Xavier, is there a way for you to unmute everybody and then just go back in and mute
That's what I was
everybody?
thinking. There has to be a way to control it from the
The
panel.
options are pretty limited on WebEx. Let me
Oh,
try.
there we go. We can hear him from the phone. I can hear him fine. Can everybody hear him okay? Okay.
I can't hear him, but that's okay.
We can translate. There we go. Or put a microphone by the phone. Yes. Okay, we're gonna put a microphone by the phone, Miss Faith, and we'll see if you can hear him then.
Super.
All right, Mr. Garcia, can you hear us okay?
Yes, I will hear. I will hear the phone.
Okay, great. Miss Faith, can you hear that?
Yep, beautiful.
Yes.
Perfect. All right, let's go to history of the property, please.
Oh, yeah.
Oh, yeah.
We didn't swear him in yet.
That was the issue. Let's go ahead and swear him in. Go ahead, Mr. Madison.
Mr. Garcia, can you please reply if I do? Say your name and spell your name for the record.
Yes, I do. I, Enrique. ENRAUUA.
Enrique, what's your last name?
Garcia. GRRCA.
Okay, and do you swear to tell the truth?
True, yes, true.
Okay,
Thank you.
perfect. Thank you so much. All right, let's do history of the property.
Thank you, Madam Chair. We read the history of the property on September 15th, but I'll read it again. There's been no change in the zoning since 1929. We didn't find any records in our Records Administration Office, but we did see that in the more recent history in our Acela system, that in April of this year, a certificate of disclosure was issued to the property stating that the use of the property is as single family. Then there was a permit applied for in May of this year, May 19th, to re-roof the property. And also there was a vacant building registration issued to the property in April of this year. That's all that I have. No variances on file. Thank you.
Okay, thank you. Can we have legal, please?
Madam Chair, members of the board, appellant is requesting an area variance from the front yard setback requirements of the zoning code. To obtain the area variance, appellant must prove that denying the request will create a practical difficulty not generally shared by other land or buildings in the same district, will deprive the appellant of substantial property rights, and that granting the variance will not be contrary to the purpose and intent of the zoning code. And then there's a note, the board is limited in its ability to grant a variance for a front yard setback under section 329.0C.
All right, thank you for that. And Mr. Garcia, do you want to give your comments?
Yes, my proposal is to.
Wait, can you speak into the phone?
Oh, okay, yes, my idea is to review the all porch because the porch right now is missing. But my idea is to review same. I not change the dimensions. Size, everything is same. But because right now I have problems because the deck to have when the raining or when the snow, the water is into the basement. I need the protection of this area in the front of the home. If I don't understand because my area is same dimensions, same size, everything in the old porch. The first time I would do the proposal then close. But right now I submit the new drawings and showing the proposal is open porch, same of the old.
Okay, thank you so much for your comment. Any questions from the board?
Madam Chair, as Ms. Leonard pointed out, this is a foundation. The front and side walls of the porch are masonry, so the appellant would be hard pressed to move it. He would have to completely demo all the masonry and then rebuild it. And I suspect that underneath that front porch in the basement, there's probably what used to be coal room or storage room. So it would impact the entire structure of the house if he had to demolish the masonry front porch.
Okay, sounds to me like you have a motion then, Ms. Faith.
I motion that we approve calendar 25-148.
All right, thank you. Do we have a second?
Board Member Madison, second.
All right, can we call the vote?
Ms. Holzer?
Yes.
Mr. Madison?
Yes.
Ms. Faith? Ms. Wilson?
Yes, and I'm glad we have Mr. Garcia online with us to hear the vote.
Calendar number 25-148 is granted. It'll be
Yes.
ratified on Monday and we will send the appellant a letter.
Okay, Mr. Garcia, you are all set. Your calendar number has been approved. And you will hear from our office next week.
Okay, thank you. Right now, I'm in Berlin, but maybe to return to Cleveland in 2 months. Is possible to present in two months, no problem?
Do something in 2 months. Anybody catch that?
Didn't catch it.
Oh, you're saying you want to get started with your project in 2 months?
Yes, this is my agent.
Okay, yes, that's fine.
Okay, and so only need to present in the office or to get my permit?
Yes, you will need to come down to the city to get your permit.
Okay, thank you so much.
Yes, you're so welcome.
I'm sorry for my breath English. I am old person. In the United for here, when the people is old, it's very difficult to learn other language.
I understand so much. That's okay. You have a good day. Bye-bye.
Thank you so much. Bye-bye.
All right, that concludes our cases for today. We're going to go ahead and address old business. We have calendar numbers 2 through 6 that are up for ratification. Any objection?
No objection.
No objection.
All right, those are ratified without objection. We do have one request for rehearing. This is calendar number 25-125.
Madam Chair, that's just a miscellaneous informational piece, letting you know that calendar number 25-125 has been appealed to the Court of Common Pleas. And that's regarding 3005 Clark Avenue, Jammer Properties LLC, proposing to use the space as a smoke shop. This board denied the appeal on September 8th, and they have officially appealed to the Court of Common Pleas as of last Thursday.
Okay, understood. That concludes our old business. It's 11:02. We are adjourned. Have a
Thank
great
you.
day, everyone.
You as well.
Thank you.
Thank you.